Welcome to OhioLandlordTenant.com. My name is Eric Willison. I am an attorney in the Central Ohio area, and today we're going to be talking about what a tenant needs to do if the landlord isn't fixing things around the apartment. Now, one of the things you don't want to do is just stop paying rent. The problem that you run into there is that can lead to an eviction. However, the Ohio legislature back in 1974 passed the Ohio Landlord Tenant Act, and that's still good law today. What it says is that under Ohio Revised Code 5321.04, that the landlord has certain duties and obligations to the tenant. One of those duties and obligations is to put and keep the rented premises in a fit and habitable condition. Now it goes into a little bit more detail than that, but that's the general gist of it. Now, if the landlord fails to accomplish his duties under 5321.04, then the tenant needs to turn to 5321.07 to find his or her remedies. And what 5321.07 states is that if the tenant is current on his or her rent, and if the landlord is in breach of his 5321.04 duties, then the tenant needs to send written notice to the landlord of the problems. Now, once the landlord gets that written notice, the landlord's got 30 days or a reasonable time, whichever is sooner. Now, that means that the longest that the landlord can take is 30 days to fix the problem, but a court could determine that it should have been fixed sooner than that. But anyway, the landlord has got that amount of time to fix the problem, and if the landlord does not fix the problem within that amount of time, then the tenant has one of three options. Option number one would be to go down to the clerk of courts. Usually if there's a municipal court in your area, then that's where you want to go. And you can start escrowing your rent with the clerk of courts. What that means is that you would fill out a rent escrow form with them, show them a copy of the letter that you sent to the landlord, warning him about the problems, and then you would start paying your next month's rent to the clerk. The clerk would then accept that rent, cash the check, and send the landlord a letter saying, something like, "Dear landlord, you would probably be wondering why you're not getting any rent from this certain tenant at this certain property, and that's because we're getting it, and we're not going to release it to you until we either have the tenants okay, or until the judge comes in, takes a look at the situation, and determines that it's for some reason not proper for the tenant to be escrowing the rent." So now the rent will continue to pile up in that account until the landlord either fixes the problem, and then at that point the tenant would release the rent, or if there's a dispute about whether the problem is fixed or not, then there would be a hearing on the matter, and each side would get to present his or her evidence. Now, the second option that the tenant has would be to also start escrowing the rent, but file what's called a motion to compel repairs with the court, asking that the court order that the premises be repaired. Now, in reality, what tends to happen is that after a hearing on the issue, the court will say to the tenant, "Why don't you go ahead and repair the problem yourself and pay for it out of your own pocket, Mr. or Mrs. Tenant, and then bring us a bill. And then if there's enough money piled up in the rental escrow account, then we'll take that bill and we'll pay it back to you that way." So the tenant will initially be out of pocket, but in the end will get his or her money back. The third option, if the problem is severe enough, a threat to the tenant's health or the health of others, would be to allow the tenant to terminate the lease and vacate. Now, that's a pretty drastic remedy, and you have to be very, very careful in exercising it. If you've got a situation where you've got sparking outlets, or if you've got doors that will not close or lock so that the place isn't secure, if you've got some sort of sewage backup or something like that, those would be the kind of very, very severe problems that might allow a tenant to terminate the lease if the landlord fails to repair. But if it's just something where there's a light bulb out, or the ceiling fan buzzes or won't work, or maybe an exhaust fan in the bathroom doesn't work, typically a landlord, while they do have a duty to fix those things, a court is not going to allow a tenant to terminate the lease with regard to those sorts of things. So that is the tenant's statutory remedy, is to go and start escrowing the rent with the clerk of courts. Now, I would caution you, of course, you must escrow the rent with the clerk of courts. A lot of people say, oh, I'm escrowing my rent by just not paying the landlord and I'm keeping the money in my own account. Well, that's not statutory escrow. That will get you evicted. So if you want to avoid an eviction action and get things fixed around the place, follow the dictates of 5321.07. And if the landlord does then try to evict you because you are escrowing the rent, the case law in Ohio repeatedly says that that escrowing the rent is a complete defense to failure to pay rent in an eviction action. I hope you found this to be helpful. If you want a more detailed printed out version of what we're talking about with cites to case law and cites to the statute and all that sort of thing, you could order one of our ebooks on the subject. Just go to ohiolandlordtenant.com, click on the tenants' rights button, and you'll come across an area which talks about what to do if your landlord won't fix things around the premises. Thanks for listening, and I hope this helps.